Sheriff Ryan Cain said 16 words about the Siders' home. Those 16 words are now Exhibit A in the defense's motion to protect the jury pool. I want to read the sentence out loud one time, slowly, because a sentence that becomes evidence deserves to be heard clearly. Livestock are generally held in better conditions than these children were. That is what he said. That is what the defense is now trying to bury. And that is what we need to talk about tonight. Sit with me for a few minutes, because this one is not just about the Siders case. This one is about what happens when a public official tells the truth in plain language, and the truth becomes a legal weapon somebody else can use against the prosecution. It is a story you have probably not heard told this way before, and it matters. Let me set the scene for you. Sheriff Ryan Cain runs the Vinton County Sheriff's Office. That is a small department in a small county in southeastern Ohio. Rural, farm country, rolling hills, small towns, the kind of place where the sheriff knows most of the families he polices, and most of the families know him. When the June 30th raid on the Omer Street house happened, Sheriff Cain was one of the officials who spoke publicly about what his deputies had seen. He did not use lawyer language. He did not use press officer language. He spoke the way a rural sheriff speaks, plain, direct, honest, and he said the sentence I just read to you. Livestock are generally held in better conditions than these children were. Now, if you grew up around farms, that sentence lands differently than if you grew up in a city. Because in rural America, livestock are actually treated with a lot of care. There are laws about how you house them. There are laws about how much space they need. There are laws about how you feed them. There are inspectors who come out to check. So when a rural sheriff says that children in a home were kept in worse conditions than livestock, he is not being cruel. He is not being dramatic. He is being specific. He is saying, in the language of the land he grew up on, that what his deputies walked into on June 30th was worse than anything a state farm inspector would tolerate for a barn full of cows. That is a hard thing to say, but it is a true thing if the reports are accurate. The problem from a legal standpoint is not whether it is true. The problem is when he said it, and where, and to whom. He said it at a press conference, he said it in front of cameras, and he said it in a way that got repeated on every television station and in every newspaper in Ohio and then across the country. That is the thing the defense cannot let go of. Because when a sheriff makes that kind of statement in public, before a trial has begun, before a jury has been selected, before a grand jury has even convened, that statement can shape how future jurors think about the case. Even jurors who have not been chosen yet, even jurors who will not walk into a courtroom for another year. That is what lawyers call jury pool contamination. Let me explain that phrase, because it sounds more complicated than it is. Every county in America has a pool of adults who could potentially serve on a jury. When a trial starts, 12 people are chosen from that pool. But before they are chosen, they are asked a question. Have you heard anything about this case that might affect how you would decide it? If they say yes, and if what they heard was strong enough, they cannot serve on that jury. So when a sheriff makes a very strong public statement about the condition of a home weeks before a trial begins, every potential juror in that county who hears the statement is now potentially contaminated. They have heard something dramatic. They have formed an impression. And when they are asked months later whether they can be impartial, some of them will honestly say no. If enough of them say no, the county cannot seat a jury. The trial has to be moved to another county, or another jury pool has to be brought in from far away. That costs the state money, it costs time, and it opens the case to appeals down the road. That is why the defense is going after Sheriff Cain's 16 words. They are not saying he lied. They are not saying he was wrong. They are saying he said something too vivid, too memorable, too colorful, at a moment when the case had not even reached the grand jury yet, and by saying it, they argue, he made it much harder for their clients to get a fair trial. That argument shows up in a motion the defense filed this week to protect the jury pool. The motion cites the sheriff's quote directly. It calls the quote inflammatory. It asks the court to consider restraining orders on future statements by law enforcement. So the sentence has traveled from a press conference microphone to a national headline to a courtroom filing to a motion sitting on Judge Featherolf Rogers' desk this weekend. That is a long journey for 16 words. Now let me talk about what this means for law enforcement across America. Because Sheriff Cain is not the only sheriff in America who talks like this. There are thousands of sheriffs and police chiefs in small counties across the country. And most of them, when they see something terrible, describe it in plain language. Because plain language is how they were raised. It is how their communities talk. It is what people expect from a public servant who is not trying to hide behind bureaucratic words. But that plain language, in a big case, can become a legal problem. And this weekend in Vinton County, we are watching that problem play out in real time. So what is a sheriff supposed to do? Should he lie? Should he refuse to comment? Should he use vague words that do not tell the public what really happened? Should he wait until the trial is over before he speaks? There is no easy answer, and I want to be honest about that. There is a real tension between the public's right to know what happened and the defendant's right to a fair trial. Both matter. Both are protected by the Constitution. And when they crash into each other, somebody has to make a choice. The choice Sheriff Cain made was to tell the truth in the language he knew. That is a defensible choice. It is also a legally risky one. Both things are true at the same time. Let me tell you what I think happens next. The judge will probably not rule against the sheriff himself. Sheriffs have wide discretion in how they speak to the public, but she may issue a new order restricting future statements. Something that says no more strong descriptions from law enforcement until the trial is over. That kind of order is common in high-profile cases. If that happens, Sheriff Cain will still be able to do his job. He just will not be able to describe the conditions of the Omer Street house in vivid language anymore. Not until the trial ends. Not until a jury has heard everything and made its decision. And that will be a small loss for the public. Because in cases like this one, the sheriff's plain language is sometimes the only honest description we ever get. The lawyers will use lawyer words. The reporters will use press words. But the sheriff, the one who was actually on the porch when they opened that door, will be quiet. That is a cost, a real cost, even if it is a legal necessity. Now, I want to sit with something harder. We live in a country where truth-telling in public office is getting rarer, not more common. Elected officials have become careful. They have communications teams. They have lawyers who review every statement. They have media advisors who tell them what to say and what not to say. And in that world, a small county sheriff who says exactly what he thinks in words a farmer would recognize is becoming a kind of rare bird. We should not lose that voice, even when it costs us, even when it complicates a trial, because the alternative is a world where nobody in public office ever says anything real, and we all lose our sense of what is actually happening in our own communities. I do not know the right balance. Nobody does. But I know we lose something important when we punish plain speech from public servants, and I know we also risk something important when plain speech makes fair trials harder. Both things are true, and both things deserve to be respected. Here is where I land personally. The sheriff said what he saw. It was vivid because what he saw was vivid. It was memorable because what he saw was unforgettable. If 16 children were living in conditions worse than livestock, then the sheriff was right to tell us. The problem is not that he told us. The problem is that our legal system has not figured out how to hold two truths at the same time. The truth of what happened and the truth of the defendant's right to a fair trial. We should get better at that. Not by silencing sheriffs, but by teaching juries to hear public statements without letting those statements decide the case for them. That is a harder path. It takes better jury instructions. It takes more careful jury selection. It takes a longer view. But it is the path that lets truth and fairness live in the same courthouse. Let me close with a thought I have been holding all weekend. There is a reason 16 words from a rural Ohio sheriff have traveled so far. It is because the sentence was true. If the sentence had been an exaggeration, it would have faded by now. It would have been fact-checked and forgotten, but it has traveled because it was accurate. That is the power of plain speech. It travels because people recognize it as true. That is worth something, even when it makes a trial harder to run. The truth is a hard thing to say without breaking the rules that protect it. Watch how the judge handles this motion in the next 2 weeks, because how she handles it will tell you a lot about where the case is heading. Thank you for staying with me tonight. Thank you for thinking carefully about what public officials say and how they say it. Take care of yourself. Take care of your family. And if you know a sheriff or a police chief or an official who speaks plainly, thank them this week, because they are becoming rare. And what they say may be the only real record we have of what our communities are actually going through. I will see you in the next update. Take care. One small piece to close on tonight, Sheriff Ryan Cain has not commented publicly since the defense motion was filed. That is telling. not because he did anything wrong, but because even a plain-spoken sheriff learns over time when to hold his tongue. He is holding it now. And that silence in its own way is a sign of respect for the process. Because a sheriff who wanted to poison the jury pool would keep talking. A sheriff who wanted the case to end well, whichever way it ends, would step back and let the courtroom do its work. That is what Sheriff Cain appears to be doing. I hope his silence is remembered when this case is finally over. I hope the public remembers that a small county sheriff who spoke honestly on one difficult afternoon then had the wisdom to stop talking when the lawyers took over. That is not weakness. That is discipline. And discipline in public office is worth more than most of us give it credit for. 16 children are somewhere safer tonight because his deputies did their job. Whatever the trial brings, that part is real. That part will not change. And that part is worth honoring. Take care of yourself. Take care of the small people in your life. Say something if you see something. And I will see you in the next update. One final small thought. If a plain-spoken sheriff, a careful judge, and a patient state agency are all working together on a case like this one, the odds that justice gets served are much higher than most people assume. It will not be perfect. It will not be fast. But it has a real chance to end well for those 16 children. That is more than nothing. Some nights, it is everything. Take care.